Tonight, we have a great session planned for you. I'd like to welcome our esteemed speaker for tonight, Alexander Levy. Alexander is a partner at Hauser Henry and Ceron LLP and has been with the firm for over 7 years. He is focused on general corporate and commercial law with a special interest in mergers, acquisitions, corporate governance, and succession planning. In addition, Alex specializes in setting up and facilitating the growth of startups and early-stage ventures. Alexander regularly advises both purchasers and vendors of multi-million-dollar mid-market private companies across various industries. He also routinely advises companies on employment matters and works with individuals on estate planning. Alexander is a graduate of JD MBA program at Osgold Hall and the Schulich School of Business and seeks to provide practical legal advice within the context of a client's business needs. Alexander, welcome and thank you for being with us here.
Okay, so we have a bit of an action-packed agenda and it's just me, so we'll try and keep it interesting with some examples. As Alina was saying, I work at a boutique business law firm downtown and always enjoy working with entrepreneurs, and because everyone seems to have such a diverse need or concerns, especially with Y-Space and the various programs. So with that being said, a quick overview of the agenda. I will touch on business structures just to give a bit of a rundown of what's available to you, although the focus is going to be on corporations, and I'll talk about that in the second part. Then I want to talk about employees and independent contractors, the distinctions between the two, the pitfalls associated with those, highlight some of the benefits of what you can include in contracts. I have intellectual property up there, but I'll say a caveat from the outset that I'm not an intellectual property expert. So these slides that I have for you today are more informative based. They concern specifics about copyrights, trademarks, and patents, none of which we implement. Our involvement with intellectual property would be more from what provisions to insert in various contracts and what that means. I also have Castle and Pippet up there, which is regarding the Canadian anti-spam legislation and the privacy laws. I've actually shipped those out of the presentation, but if you do have questions about privacy laws or the Canadian anti-spam legislation, in the latter legislation there, the anti-spam, if you have marketing efforts and you're trying to drum up business by mass emails or anything like that, then please let me know and I can answer those questions. And lastly, I'll touch on shareholders agreements and employee stock options. And my goal is really going to try and tie the circle, so to speak, how your business structure fits in with those three. So with that all being said, before diving into the other topics, I did want to talk about business structures because I think it will provide a bit of a helpful overview. And what I have listed here are sole proprietorships, partnerships, and corporations. And you've probably heard of each of these, and we're all a Google search away from getting a Coles Note snapshot of what the advantages and disadvantages might be. But like most things, what's best for you is going to be a little bit nuanced and tailored to your needs. And as I said before in this presentation, I am going to focus almost exclusively on corporations as it tends to be the dominant choice. But that being said, let's dive in. So for sole proprietorships, it's what we most often think about when someone has an idea, they've acted on it, and now the business that's been started is starting to generate some expenses or revenues in pursuit of this idea. It's really what comes to mind when you get a bill from a small business. There's no Inc., Corp, Limited, or Corporation next to the name, and that's the first clue that you are not dealing with a company, despite the appearances. You're actually dealing with an individual. So for sole proprietors, the key aspect to note is that there's no corporate shield. The contracts that you're signing, although signed under a registered business name, is the actual owner's personal obligation. The buck stops with the owner at an individual level. And what's interesting about sole proprietorships is that the profits and more importantly, the losses are flowing directly to the sole proprietor. That's actually one of the main attractions of it. So for that reason, people like it because, well, it's not like we all want to have giant losses to flow back, but at those early stages, it's nice to have the losses hitting and reducing your personal income tax bracket. And that's one of the main advantages of them. Now, to balance that out, the main downside is you don't get the limited liability from a corporation that you would have in a corporation, and it's hard to raise capital. Another major downside of the sole proprietor is if you're thinking of growing your business to the next step in getting investors, it's even hard to call it a structure, because it's really, if you think about it, what is that investor investing in? It's difficult to attract capital. There's really nothing to invest in, since you are the business. The owner is the business. There's no corporate entity that people are pouring money into. People could give you money, but it might operate more as a loan or some other contractual arrangement. So it's quite a different concept than an investment in a company. So moving on to partnerships. Partnerships are, oh, sorry, Alina, yeah, perfect, thank you. Partnerships are very interesting. Like sole proprietorships, a main benefit of a partnership, rather, is that the income and the losses are flowing through to the partners. And this can be very attractive for certain business types. You'll quite commonly see real estate joint ventures or maybe private equity deals structured as a partnership, albeit a different kind of partnership, maybe a limited partnership, to capitalize on this sort of tax treatment. And that's where I'll end with tax, because we are not tax experts. And so I don't want to focus on the tax benefits of each of those too much. I'd be doing everyone on this presentation a real disservice by diving into it. But what I do want to mention is that forming a partnership tends to be a little easier than a corporation. Maybe not if you're doing it to the letter and very with a sophisticated partnership agreement. But what I mean by they're easier to form is you can form partnerships by accident. There's really no filing, like filing articles of incorporation, because what you're doing is you're registering a business name. But as I just mentioned, you can do it by accident. So I'm almost flagging this as, hey, this might be a pitfall. And forgive me, I live in a world of worst case scenarios and get those types of calls. So I'm inundated with that. I'm not saying this is likely to happen to you, but you can accidentally and inadvertently form a partnership when that's what you're portraying yourself as to the outside world. So if you're always referring to your business partners, you're signing off as emails as partners, and you, I'm making this up, it seems silly, but it really does happen. To that outside third party, what you're communicating is, I'm part of a partnership. This is my partner. And under the rules of general partnerships and the Partnerships Act, you might be at risk that your partner could go do something, and now you're bound by that because you've been demonstrating that you're actually partners. So that's even without filing something, which is kind of scary. So I just, on that note, I'll leave partnerships because I don't think it'll be a hot topic of the ultimate formation of what people on this call might be deciding to do. So with that segue, I'll just dive right into the last business structure, which is corporations. Corporations are interesting. They're a distinct legal entity, and they're by far the easiest entity in which to raise capital in its simplest form. People can wrap their heads around it. You can create and sell various types of share classes, and investors tend to have a readily identifiable way to share in the future growth of the business, which is one of the main issues that I was highlighting with sole proprietorships. Also, it's that distinct entity. So the corporation does not end if the shareholder dies or walks away from the business. The corporation lives on. One of the main benefits too, a corporation is well known, for better or for worse, that it shields its directors and owners from a significant amount of liability. So as a shareholder, really your main stopgap in liability, for most cases, tends to be exactly what you've invested in the company, which is very attractive. But one question we're often asked is, what am I liable for as a director? Maybe even an officer, but I'll focus on director. It'll be similar concepts, but I think directors have a little more exposure. And it's actually a really complex question depending what's going on, but I'll try and give some key points, which is really what I think you might want to take away from all this. So if we've learned anything, and I guess I'm going back a lot of years now, but if I'm going back from the financial crisis and you're asking me what are directors liable for, I think we all learned not a whole lot. I can't recall many directors of companies being carried away in handcuffs for what was probably a lot of wrongdoing. But that being said, some key things directors might be personally liable for are unpaid taxes, unpaid wages up to a certain maximum threshold. If anyone's out there in real estate, environmental claims, it's huge. I would never become a director of a company that's owning commercial real estate without being a little bit in the know and making myself aware of exactly what is going on. That's a whole topic in and of itself. But the main one is really a director's main source of liability is if it breaches its fiduciary duties to a company. The director does so. So to sum it up, what your duties are is basically to act. Oh, sorry, still previous one. It's a little rambly, Alina. I'll give you a note. I go off on a few tangents. But directors do have a duty to act honestly and in good faith and in the best interest of the company. That's a simple statement, but a loaded statement. But the bottom line is a director can't shield itself from herself from liability by simply burying your head in the sand. It's not a defense to simply say, well, I didn't sign off on that. I had no idea what was going on. As a director, it's actually your job to take reasonable steps to inform yourself of what is going on. And that is your best protection. That's when you get the deference. So attend the meetings when they talk about the financials. And if you aren't versed in financials, ask people who are and inform yourself. That's your best defense. This isn't to say I'm worried about anyone becoming a director of your own company. Just maybe consider that next time if you're ever asked to join a board. So just to flesh out this column a little bit, I have in the not so good column, the regulatory environment of corporations and maintenance costs. I felt a little bad about putting that in there. And it is true that to maintain corporations, it might cost a little more than business structures, but I think the concerns in that regard might be a little overblown, particularly for early stage companies. It's really not so onerous. If I created a corporation tomorrow, my only real obligation is to file tax returns every year because it is a distinct legal entity and a government filing. And then every year, yes, you should be keeping your corporate records up to date. But that's it. Those are your obligations. And if it doesn't work out and you don't have a lot of assets and liabilities, you can wind it up relatively quickly. So it's not like once it's created, it's some black hole that you can never get rid of. So for a reasonable expense, you can get things started. I would just say that the real reason not to incorporate, I wouldn't be so intimidated by cost, but it's really all about you. And if you're unsure about how long the business will last, and maybe you're just not at the right stage, it's really a judgment call, and that's absolutely fine. But I just wanted to dispel some of the immediate concerns that people might have about what it means to be incorporated and how do I wind it up if things don't go well, or what are my ongoing costs on a yearly basis. So that being said, Alina, I'll move it along for real this time into incorporations in a little more depth. One of the key questions that we get asked all the time is whether to incorporate provincially or federally. And honestly, practically speaking, I do not find there's much of a difference. So if you incorporate provincially and are governed by the Ontario Business Corporations Act, the good news is that act is largely modeled on the Canada Business Corporations Act, which is the legislation you would follow if you were federally incorporated. If you were reading the two, despite the section references, and you're reading the same clauses about the same materials, you're almost going to be in word-to-word territory on a lot of the items. So that's just from a pure legislative standpoint. From your daily operations, even if your intention is to go public one day, it doesn't matter. There's many companies that go public. I don't want to say most. I don't take companies public or anything like that, but it's not a hindrance. It's not going to shoot your long-term prospects. Some people think you have to be federally incorporated it makes it easier to do business Canada-wide. That's not true. If you're federally incorporated, you still have to register in each province you're doing business in. So to contrast that with incorporating provincially, you're already, if you incorporate Ontario, you're already ready to go in Ontario. And then if you wanted to do business in Alberta, and we could talk for a while about what doing business means, I wouldn't overthink it, then you would just simply register to do business in Alberta, just like that federal company. So it's the same bureaucratic policies to follow in that regard. But probably the biggest deciding factor, at least that we come across, is director residency requirements. To me, that's the one that usually tips the scales, and it usually tips the scales in favor of provincial. And that's because if you're federally incorporated, at least 25% of your directors have to be residents of Canada. And only Ontario, New Brunswick, and BC don't have that requirement. In Ontario, that was really probably within the last year and a half, which has been fantastic, because it really is very annoying to have for someone who would want to incorporate Ontario has to all of a sudden do it in BC. So lots of foreign entrants come into Canada that way. So do not overthink which jurisdiction, in that you're really giving up something by doing one or the other. So in the next slide, I talk about some of the reasons of why incorporate, and I did cover that a lot in previous slides. So I just want to point out a few additional things. And the first one is it's quick and easy. And many people might know this from experience. There's a lot of online resources out there, and with a few clicks of a button, we could all have a corporation by the end of this presentation. It's not so much the incorporating part that I caution on. All of my cautions are for further on in the presentation. It's setting it up, but the incorporation process itself, even the organizing the company part, is pretty straightforward. Doesn't matter how big or small the company is, 99 times out of 100, it's going to be quite a simple structure, especially at the outset. It really only tends to gain complexity if there's good tax reasons or good things are happening to your company down the line, and you need that complexity. So to actually get it set up is pretty straightforward. And the other point I wanted to mention, albeit briefly, is the tax considerations and the flexibility in future planning. And what I mean by tax rates, and I feel comfortable talking about this tax rate, is we've all probably seen in the news that corporations aren't taxed like human beings are. They benefit from lower tax rates. Well, that's a huge incentive for them. And what that would allow you to do as a company is now you can accumulate wealth in your company a lot faster than you can by yourself, because you're getting taxed at, let's just say, 15 to 25%, and individually your tax rate might be higher. So all of a sudden your corporation is benefiting from maybe tax losses it had, and it's taxed at a lower rate, and now you're accumulating wealth in your company and reinvesting that into the company. So it's a quicker way to ramp things up that way. And then I'll mention another a tax benefit from being an incorporated entity that this is the dream. One is that everyone's eligible for a one-time lifetime capital gains exemption. So if you started a company and it's worth $1 and you grow it into $1 million, well, and then you sell the company, that's the key. And there's a bit of a test behind it. You can get up to $900,000 approximately of that sale price tax-free. And there's a lot of funny tax planning you can do to even make sure not just you, but your family members, and there's family trust vehicles. That would be more common. Anyways, if your corporation is doing really well and your business is really growing, that's something to just ask about. Like, hey, what should I be putting in place now for my future growth? So I just want to raise taxes as key reasons why people really like corporate structure. So with that all being said, I want to move on to what mistakes not to make. What can we try to prevent? What are these dangers that I'm talking about from maybe incorporating too quickly or online, or not giving enough thought to certain things? And this is going to seem really simple, but it can and does happen all the time. And the first is issuing shares. I know the services are getting better online, and I'll be the first to admit to you, I don't exactly use them. So I'm sure they've gotten better. So I just want to flag that people sometimes forget to organize the company. And what I mean by organize is they forget to issue the shares, properly document that. And all of a sudden your share capital is a mess. and you're going to get an outside investor, or you just have you have a dispute between business partners. Well, what do? Your corporate records are a mess. You can't really recall who was issued what shares, who contributed what. It gets really messy. And I'm not saying we can't get to a resolution. Most times we can, but it's now at a far greater expense and hassle and worst case scenario litigation. So it goes from a quick fix of maybe it's something you didn't even have to fix. It shouldn't have even been an issue, to a potentially drawn out affair with very uncertain outcomes. So unless this is documented properly and you're really paying attention to your capital structure, just keep in mind that incorporation by itself is only the first part of the process. It's like anything. If you're doing it right from the start, it's actually simple and cost effective, almost free after you're running. You just have to make sure you're really maintaining it and not getting lost with things like stock options and things flying around like that. Another one is properly describing share attributes. I see this less. It's just, we've been in situations sometimes where we're tagged in for one thing or another. It doesn't even have to be a dispute. And you're looking at the share classes and you might see common shares, preference shares, non-voting shares, and that's it. You literally just see those words. Well, that doesn't mean very much. Just saying that doesn't mean anything. What you're saying in the share attributes matters, because part of what you're saying in those attributes, especially if you have different types of shares, you could be saying which shares are growing as the company goes from $1 to $1 million, which shares are not participating in that growth. Or maybe we can declare dividends on this class of shares and not that class of shares. And it's not always going to read the way you think it would read. Your share attributes aren't going to say this share grows, this share doesn't. It won't read like that. So it won't pop out as being super obvious. But I was dealing with a founder, and no harm done. It was just him. And I was looking at the share attributes, and he had 1 million shares of some. And keep in mind, you can issue shares at the start for like $1 for 1 million. So it sounds nice, but it's really worth $1. But those shares weren't growing at all, and he was about to issue stock options. So it was a very fine moment of, okay, we got to make sure you're issuing the right shares to new people as they come on, and you have the right shares and they say what they want to say. So you need to make sure you get that in order. I'll talk quickly. This is kind of an interesting one, is the private issuer exemption. The concept I'm really driving at with the private issuer exemption is you want to issue shares. You want to issue shares to your family, to your friends, to your business partners, to your employees. Those tend to be the common no-brainer ones at the outset, and everyone does it, and they do it freely. But when you're issuing those shares, you're really only allowed to do so because there's a specific exemption in securities laws. There's many laws out there to protect unwary investors from being hoodwinked by business owners selling shares. You can't just freely go to a stranger and say, invest in my company for $200,000. Let's go. The laws are there to protect all of us from that happening. But there's an exemption to allow you to issue shares to those types of persons if you have the right language in your articles of incorporation. I'm not saying that if you don't have that language, the world is crashing or anything like that. It's just picture a scenario where you lost all of your best friend's money and they're looking for, maybe they're not your best friend if they're about to do what I'm about to say, and now they're looking for a little bit of recourse. People will get desperate. So you just, again, it's simple, it's easy, and you can really do it right from the start. And sorry, next slide, Alina. I'm not going to go into depth about these. I just wanted to leave on this message before we leave the topic of incorporations, is that we've covered some of the basics of right structure, when to incorporate, which is a judgment call, and some of the pitfalls to avoid. And just really want to highlight that it's the start of the journey, and it's important to always contemplate how the company is going to function and function best for you beyond inception. So we will cover some of these details later on. I just want to leave you on that note as items to keep in the back of your head as we go on to the next topic. and that is independent contractors and employees. I really like employment law. I don't know. I just find it's one of the most personal areas of law. It's just very impactful. And it's one of those areas that I find if you're going to invest money in anything to do lawyer-wise, I would say an employment agreement is one of the easiest things. You'll get so much return on your investment for that initial contract, and I'll explain why throughout the section. The funny thing about independent contractors and employees is that a lot of the time, both parties, and maybe calling them employees is wrong, but both the company and the person they're hiring would actually prefer to call that person a contractor and not an employee. From a company's perspective, a contractor is just simpler. There's no payroll, there's no source deductions off paychecks, there's no benefits, eligibility you have to worry about. And most importantly, there's none of this overtime, vacation pay, all the Employment Standards Act protections to worry about. And as for the individual or company being hired, a huge perk of being classified as a contractor is you can write down a lot of expenses. They're trying to capitalize on this beneficial tax treatment. All of a sudden, instead of being an employee, they're a contractor. Pretty soon, they're going to start deducting meals, entertainment, cell phone bills, all those things. They're going to be treating themselves like a business. So they're going to reduce their income that way. So many, many times, businesses large and small are like, great, contractor relationship works for both of us. The problem is when it all comes to a head, and it usually comes to a head when the relationship is terminated or breaking down. And companies will find it's at this moment that their former happy contractor is fighting and all too happy to be classified as an employee and benefit from the protections under the Employment Standards Act. Because all of a sudden they're going to want their severance, wrong term, but their termination pay, their notice. They're going to want all that unpaid overtime, all that unpaid vacation time. And to cap it off, you as the company owner also haven't been making all those source deductions off of the paychecks that that person really would have been getting if they were an employee. So all of a sudden you owe the government a lot of money because where's all those CPP source deductions? Where's all the payment into our social welfare systems and things like that? It really can hit you on the side of the head, which is why on the next slide, we can go through some of the factors of determination into what's what. And it seems clear, but the lines can get blurry. Now, I highlight this case just because it's a high level case and they throw some good points to consider. So if the worker is working exclusively for the company, if the employer has a lot of control about how the work is conducted, the company is providing the worker with the tools, has the worker taken on risk in relation to the employer's business, what's their stake in success or failure, and how integrated is this worker into the employer's or company's business. And again, it's very common that we would get approached to draft a contractor arrangement, and we're asking the questions, and the first thing is, well, how many hours of work per week? 40. Okay, that's a lot. I don't know if this person is outside client. Sounds like they're just you here. What's their role? Director of sales. Well, that sounds pretty integrated to me. And it sounds a little funny, but you're playing a little bit with fire off of that. So if you're a company and you're looking for an easy delineating factor to say, oh, no, for sure, contractor, I don't have one for you, but a really key one would be to have them state in the contract that they have other clients. We can protect you with the contract to a certain degree. The contract is not going to save you from an improper classification, but the contractor can really help spell out your attempts and get them to at least think about the items you're going to flag to make that distinction clear and give you as much comfort as you can. Okay, I'll move on to some of the obligations. I'll be doing a bit of a deep dive into this topic just to give some close notes because I do find it interesting. What I want to stress on this topic of employers and employees is if you're ever an employer, keep in the back of your mind how disagreements are going to be interpreted by courts, or at least in their history. And the courts are going to view the relationship as one of an imbalance of power. And I actually agree with that assessment, because if you've ever been employed or tried to negotiate with your company, you might have felt intimidated. The company has more knowledge, expertise, resources, presumably, and of course, the ability to terminate your employment. So 9 times out of 10, it's the employer that's holding the cards. And that's why decisions in contracts are not always seen by courts between 2 equal parties operating on a level playing field. So that describes the arena you're in when stuff goes wrong. And it places a lot of importance to have a nice, carefully drafted agreement to govern the relationship. And speaking on that note, because it'll tie in, is there's a misconception about employment laws, and it's kind of crazy, because if you read the Employment Standards Act, and a lot of clients do, which I think is incredible actually, they'll go on there and read it and say, great, well, by this act, word for word, here's an example. You can terminate an employee and give them 1 week's notice per year of service up to a maximum of 8 weeks. That is almost literally what the act says. And then if you just think that, you're wrong, because the employer is not availed of that right unless it's specifically drafted into the contract and done so very carefully. So I do find it misleading. The act is there to set out the minimums. It's not there saying that this is the way things are. So it's up to the employer to include those types of things in their contracts and really protect themselves. And if you go to the next slide, Alina, I think I have. Oh no, sorry, move on to the contractors. We'll flip back to employees, but there's a lot more to say about that. It's a good contrast point, actually. Oh, sorry, if you go forward again, my apologies. Yeah, so I'll just contrast quickly here with contractors, and this more highlights why businesses like contractor relationships a little more. Presumably, between 2 commercial entities, courts are likely to infer that there's slightly more equal bargaining power. It's a little more, well, contractor, you truly should have gone out and got legal representation to represent yourself and review this. And you're not governed by employment law, you're governed by general commercial laws that we're all subject to. So those are the differences. It's a completely different ballgame if someone truly is identified as a contractor. But I'll add one interesting point here. And before we move on to the next slide, this is sort of complicated. It's kind of weird. There's an in-between status category, just so you know. So you have employees at one end and you have a contractor at the other. There's also a funny little zone called a dependent contractor, and you could fall in there by accident. This is more like a beware for companies. So we talked about equal bargaining power, but courts also say that's not always the case. What if you, company, are 60% of this person's revenue and you just pull the plug on the relationship? Well, you can't just do that. You're 60% of this person's livelihood. So they've stepped in, and there's a whole other classification, and they will look at that dependent contractor as if they're an employee from a termination perspective. So you really need to have agreements in all manners of these that really have watertight termination clauses, because I don't know if I'm ruining future material here, but your notice obligations, your termination obligations could go easily from 1 week per year of service to a maximum of 8 to absolute ballpark 1 month per year of service with no cap up to like approximately 2 years. So it gets pretty serious pretty fast, even for a 3-4 month relatively high up employee, if you're not careful. I don't know if I know probably all starting out here, but it's just in the back of your head because the years creep along. So what happens now, and it's not like you can put an employment contract in someone's face in year 2 and say, oh, sign this, I just took away a lot of your rights. It goes back to equality of bargaining power, the court will say. Well, you basically put a gun to that person's head and said, sign the dotted line. How could we enforce that? So it's not a quick fix. It's a more expensive fix at that point in time. Okay. Yeah, this slide, I'm not going to get into depth. This just highlights some of the things that the Employment Standards Act, which is noted as the ESA on here, will address. So if you have questions about any specific item, happy to chat, but not a lot more to say on that, because what I want to do on the next slide is I want to talk about some interesting topics. Just to explain, I don't know, I find some of these situations fascinating. Termination clauses, we could do a whole 2-hour presentation and I could show you termination clause after termination clause. And you think they're airtight, but they're not, because the courts are always looking to poke holes in a termination clause. And once a termination clause is declared invalid, it just wipes it out. It's like it never was there. And now we're in that realm of 1 month per year of service ballpark that I'm talking about. So it's actually a shocking concept. You could have a termination provision that gives someone $1 million, but it doesn't include benefits. Well, you're offside because you have to make them whole. It gets a little wild if you want to really take that to the nth degree, but courts do. So I would say an employment agreement that doesn't address termination is useless, in my opinion. I toss in probation here because probation's a real funny one, because everyone has the thought that, oh, if it's before the 3-month line, we can terminate no cost. That's not true. You only have that right if it's in your contract. And you also only have that right if you actually gave the person a fair shot. They can't start, you put them on the sidelines for 2 months, you say it didn't work out, shake hands and say goodbye. Push comes to shove, this probably isn't going to surface its head. It's been a short duration of time. No one's too angry, but it does happen. What if you lured that person over from another job? Never gave them a fair shake? That just ups your termination amounts that you might owe them. Layoffs are sort of fascinating because no one used to pay them much mind at all. But then COVID happened and everyone started getting laid off. And companies could only do that because they amended the act temporarily to state, don't worry if you don't have the right to lay off an employee in your employment agreement, we will allow it and not consider it termination. So now if you're going to sign a new employment agreement, it's probably going to have a layoff provision. And companies are now availing themselves of that right. It's becoming a very standard clause. I tossed in vacation pay is payable on wages, which might sound very silly, but I mention it for one fact. Maybe you're in a business that has commission payments or non-discretionary bonuses. Non-discretionary bonuses meaning the employee knows that if company revenues are X or they do Y, they get money. And it's a formulaic thing. It's not a question, it will happen. Or you have a strong history of this is the way we do things. You've just moved from discretionary to non-discretionary. And when you're non-discretionary bonuses have vacation pay payable on them. And I highlight this because I was in a fascinating, mildly, actually it was horrible, but situation where a rather large client, someone was terminated and they asked for all their vacation pay on the bonuses that were never paid every year. Well, this has been company policy for 40 years and there's like 200 employees. Wildly different scenario than what we're in, but it just starts, all these quirky things can really add up if you're not paying it much mind and people don't give it much thought, especially that one. Or maybe commissions are very important. You have a commission calculation, but maybe you didn't factor in that 4 weeks vacation pay per year, which is 8%, are payable in addition to the commissions because you never made abundantly clear that your commission structure was inclusive of vacation pay. You can just set yourself up right from the outset with stuff like that. And lastly, non-competes and non-solicitations. I'm sorry, I should have given them this maybe a little more attention because I know these are big items that people focus on. Non-competes, this will be short because the government recently passed legislation effectively banning the use of these after, I think they still apply to ones entered into before October 2020 or 2021. But now in an employment agreement, it's generally not enforceable, which I do like because they're more used as scare tactics. So for non-solicitations, they're primarily used to discourage employees your former employees, when we're really looking at them, from going and soliciting business from customers that they used to deal with, or soliciting your employees of the company. And the key thing to know with these, sometimes people slip them in commercial agreements. Maybe someone's looking at your company, maybe you're looking at another company and you sign an agreement that has a non-solicit. It's like, well, did I just agree not to solicit your customers? I'm after your customers. I just wanted to buy your company. But more importantly, what I wanted to get at for non-solicitation from this employment angle is that they have to be narrow in scope. You have to draft them very carefully. And since the government just banned non-competes, you can't have a non-solicit that expands too far and says something like, oh, you can't even do business with our customers. That's a non-compete. You just said I can't solicit them. I can't pick up the phone and send them emails. They can call me and I can do business all day long. I just can't solicit them. So if you have any questions on the nuances of that, happy to chat further. But for now, I just highlight some of the things to consider in a contractor relationship. They're sort of self-evident, but some of the interesting parts about them is termination clauses still matter. Even though it's business to business, if you don't have a termination clause, you'll be under a very similar test that employees are. It'll start being, well, how long was the relationship? How important are you to this contractor? They don't want you pulling the rug out from under people. What if you're their sole supplier? And now you just said on Tuesday that we're over on Wednesday? No, you've been in business for 10 years. You owe them 8 months. That happens. That's very real. So termination provisions really do matter in contractor agreements. And I'll touch on intellectual property here because it's important in that contractors, I'll touch on a little bit, and I'll touch it later on when we get to IP, but contractors are treated differently than employees are when it comes to ownership of IP. And that can get you in a lot of hot water at the outset, because for future investors, if a huge asset of your business is intellectual property, and if you've outsourced that at the beginning, which is extremely common, they really might want the proof that all the IP is properly vested in your company. And you don't want to be circling back to that contractor a year or two later and buttoning up all the loose ends. So I think I've actually covered these things. So I will move on a little bit into intellectual property. And that's what I was getting at just a moment ago when I was mentioning the IP, and I'll flesh that out a little more here, the distinction between employees and independent contractors. And it's pretty much taken as a given when someone is hired that the works they are making for you rightfully belong and vest in the company. Nothing further required. Company's not going to likely hunt you down for assignment agreements of intellectual property. It's a bit of a different story for independent contractors. The rights the company is getting is not as clear cut. So you really want your contractor agreement to make clear that the work that the contractor is doing is works made for hire, just like an employee, that the rights are vesting. And in both relationships, contractor or employee, I would still have very similar clauses. I would have clauses to boil it all down. Yes, the clause reads a little intimidating because lawyers haven't yet figured out how to condense these sentences into better words. But what it's really saying is all the intellectual property rights you have in this product you have made for the company belong absolutely to the company. If at a future date the company ever wants you to assign these rights to us to make that crystal clear, you will do so. And if you refuse to do so, we are now your power of attorney and we will do it on your behalf. That's pretty standard. I would say that's very standard. Just to take this out of the pure contractor employment concept and just talk business to business, and you're entering into doing services for another company, and maybe that's the business you're in, and it gets into an IP discussion. The only thing I would, not the only thing, but a key thing I would caution is your company, you've been engaged by another company to provide services. there's a good chance that some of the works you're going to create are going to use some of your own intellectual property. Maybe it's your base templates. Maybe it's something more sophisticated like software that you put in for every client. It's like, what are you talking about? That's just the software we do. Yes, you can use the work product, it's yours, but I'm not giving away my right to use the core of my business. So you can get tripped up in the language pretty easily. With that being said, sorry, it's a bit of a side note, but it's something to caution about whenever intellectual property is tossed around, which it almost always is in contracts. So I have in front of us on this slide the 5 main types of intellectual property rights, and this is the part of the presentation where it is a little more. The slide is going to say what I intended to say, because we don't. Unfortunately, we don't do trademarks, copyrights, patents, trade secrets. We work with colleagues who do, but it is a nuanced field. And if that is your line of work in business, it's worth going to the experts in that field to do it properly. But I will talk a little bit about it at a very high level. So for copyrights, the first one there, apologies for regurgitating the slide in some respects, but it is the exclusive right to produce or reproduce, publish, or perform the work. To keep it a good example is just think books and songs, not music, but songs. They're protecting the form of the expression rather than the idea of it. And that's why things like that are copyrightable. So on the next slide, we will see that thing to know about copyright is, yes, you do own the copyright when you create the work, but actually getting the copyright is sort of like your proof to the world that you did it. It's like waving a flag and saying it's mine. And we have here that the copyrights last for a very long time. But if I was to remember anything about copyrights, it's protecting the actual concept in its final form. Books or songs are a good way to think about it. Moral rights. This is good, because even for employees in employment agreements, and especially for contractors and contractor agreements, moral rights, you're always going to see a clause saying that the author or the employer, the contractor, whoever we're talking about, expressly waives their moral rights. Because if they don't, the author of that work may have the right to be associated with that work. And the last thing a company wants to do is go around with the product and then at the bottom have to give some sort of credit to some contractor that you hired 8 years ago, because it's their work. So you want them to waive their moral rights to the work. It also gives you more freedom to distort the work. As a company, you don't just want the right to the product, you want the right to do whatever you want with it, even show it in a ruined form or wildly different form. So you really want the express waiver of moral rights. Employee or contractor, definitely more important in a contractor agreement though. And next one, Alina. In patents, and patents are almost the other end. Well, it's not a fair comparison to say the other end of the spectrum of copyright, but here we're really talking about the invention, the idea behind it. So as you can see on the slide here, it's a first to file system. It's not first to invent. So this one is a bit more of a race to the door, and it is valid for 20 years from the date of filing, no extensions. The key thing with patents is it can't be something obvious. You can't see something we've all been looking at for 30 years and just be the first one to patent it and now it's yours. It's gotta, an intellectual property lawyer may correct me, but the general concept is that it really has to be novel and unique. It's got to be pushing something forward, pushing the boundary of something. And there's really no sort of neat limit as to what can be patented. I'm sure there is, but what I'm trying to convey is that it's very broad. It's very broad. You can patent codes, engineering concepts, things of that nature. But if you have future questions, feel free to reach out and I can either answer myself or put you in touch with our colleagues who do specialize in this stuff. Trademarks would be the simplest of the bunch. Again, we're talking it's got to be distinctive. You can't, I think it's in the next slide, but you can't just trademark the name Alex. Or Wendy's is, I guess, the best example, because they develop such a brand and such a recognition that people could actually tie it to what it is. So there's more to it than that. I just know that trademarks are a relatively affordable and cost-effective solution to giving more protection to your brand name and or logo. I wouldn't be intimidated by a trademark process. It can be pretty quick and efficient, as opposed to patents, which are quite a cumbersome filing process, because if you think about it, who's doing the determining and making the case for the uniqueness of your patent, which is now going to get the benefit of decades of protection, allowing only you to do that special secret sauce that you've come up with. Yeah, if we just go to the next one too, Lena, sorry. Trade secrets. Trade secrets, it's a term that gets tossed around a lot, and it's just a fancy way of saying confidential information. It's why Coca-Cola keeps their, I don't know if it's true or not, but I've been saying it, Coca-Cola keeps the recipe in a vault. It's because they don't want to disclose to the world what their formula is. They don't, because when you patent something or anything like that, it's public. And that's why for things like drugs, the prescription kind, you have only Tylenol for 20 years, and then the patent's off, and then all of a sudden there's 30 different iterations of Tylenol. It wears off. Where if you keep it as a trade secret, which again is just keeping something secret, there's no laws about it. It's really just how well are you protecting yourself contractually with your confidential information. So a lot of the times we get asked, how do we protect our confidential information from people stealing it? When can I share something? My answer is usually, if it's that sensitive, and it always depends on the context of the relationship, is have people sign a confidentiality agreement or have confidentiality provisions in your employment agreements, in your contractor agreements. It's not like you're completely unprotected, even if you don't have an agreement, but having the agreement just makes it rock solid and can really outline what the remedies are for a breach of it. Now we'll get into our last couple topics, and that is shareholders agreements and stock options. And I find the two kind of related, especially when we're talking about startup ventures or early stage companies. So I'll just start with shareholders agreements and a bit about it and some of the benefits. But in short, if you've never heard of a shareholders agreement, well, I guess it's exactly what it sounds like. It's an agreement amongst shareholders, typically amongst all of them. It's a big difference if it's unanimous, as in all the shareholders sign it, or it's just an agreement between two of the three of them. If it's just an agreement between some, well, it's just a side agreement that those shareholders have. But when it's unanimous, it has an elevated status. It's right up there with your articles of incorporation. This is the way we are doing things. It's a very powerful document. And I highly recommend that all corporations with multiple shareholders, unless you're all really close family members, and maybe even then, have in place a shareholders agreement at some point in time, particularly if things are looking bright for the future. And the biggest question, this almost circles back with corporations. Well, when should we have a shareholders agreement? Do we need it right away? When's the right time? It is I won't lie, it's often it's a more considerable expense than incorporating, because it can get a little complicated. It's like drafting a prenup amongst business owners. It can be touchy. So I wouldn't always advocate and say right away, but just always keep in mind that it's so much easier to do it when you're getting along and the stakes aren't as high than it is to do it later. So pick the right moment sometime in there, but that's really the balancing act when it comes to it. So some of the benefits of a shareholders agreement and why go to the expense of having this agreement created. Well, there's many. So I'll try and set out what it is intended to do. The first is importantly, it sets out restrictions on transfer of shares. It limits the ability of people to who they might be able to sell to. The reason I was struggling there is there's a big difference between a shareholders agreement amongst a person that owns 90 or 80% of a company, and there's a bunch of minority shareholders, and a shareholders agreement with 3 equal owners. It'll operate differently. The one with the one dealing with the person with the 90% owner, it's really going to be ensuring that that person can call the shots and can force people to sell their shares when that person wants to sell the company and things like that. It might not touch on the key decisions that I have here on the slide. But if you're talking about key decision making and there's 3 partners, that's probably what the shareholders agreement's huge focus is on. How do we decide when we get a loan from a bank? How do we decide when we all need to put in a bit more money? How do we decide who to hire? Who gets a raise? Who gets what salary? Can we amend the articles? Can we add a shareholder? That's what the shareholders agreement is really powerful for. If you don't have it, and the worst is when you're in actually, I was about to say a 50-50 ownership split, but you're sort of deadlocked no matter what. But you really need the agreement to punch through so that your business just doesn't get gridlocked because you just can't reach somebody or you just disagree. There's got to be a way out. I'll just jump right to the worst case scenario. And the question is, well, what does life look like if it just deteriorates and I have to now live with someone who owns 33% of the company and they're not going anywhere, or 5% of the company? It doesn't really matter. How do I do it? Well, the truth is there's certain key decisions under the Business Corporations Act where the magic number is 2/3 of the vote. So let's hope you're talking 33% and under. But if they're not playing ball and things are really not good, the good news is the minority shareholder can't do a lot. They don't have the right to be part of the business. They're not involved in the day-to-day decision making. They're actually just like that passive investor. But the rights they do have are, they're going to make you hold that annual general meeting every year. This is spiteful. I mean, this is the ugly, but it happens. So now you've never done a shareholders meeting in your life, and now you're holding a shareholders meeting. All they're doing at that shareholders meeting is they're going to say, give me audited financial statements. And you're going to have to pay $5,000 to $10,000 to go get audited financial statements, which really is a pain. Those are their 2 big levers. But where it's probably more going to hurt you, sorry, there's one question I did see in real time. Can a corporation be a shareholder? Great question. And yes, absolutely, they can be. Lost my train of thought, but sorry, where I was going with that was, if you go to sell the company or you want to put more money in the company, you can't force that person to sell and you can't force them to put more money in. So now you're going to go and try and sell a company, unless it's just a screamer of a deal and who wouldn't sign it, but maybe you can't even find that person. You can't sell the company. You can sell your 2/3 stake, but you can't sell it all. You're really not going to be attractive. And picture a scenario where you have 8 minority shareholders, all early stage employees or contractors, and you paid them in shares. Now you just can't find them. Well, your corporate records book is going to show 8 shareholders, and whoever's buying into this company or buying the company is going to want to know where that is. So those are extreme examples, but honestly, it's very true. And I did touch on financing. That one might be sorry, I'll move on soon, don't worry. But I did touch on financing because that one's a hot button topic, because things are messy in the beginning. You're pouring money into the company, and all of a sudden you look up and you say, oh, things were unequal. I put in 5 times more than this person. I must have more shares. Well, you don't. You didn't. And not only that, you can't force the other person to put in money. They're still that same 50% shareholder they were before you put the money in. So before you're really going to create an imbalance of contributions, maybe that's a good juncture. you really want to know that your contribution is going to be recognized. What are you going to take back for that contribution? A high interest loan, or are you going to take back more shares? You can decide that. And the shareholders agreement can really spell out what happens. It'll spell out who makes the decision of when to contribute more money and what's the penalty for not doing so. And the penalty doesn't have to mean you go into the other person's wallet, but it could mean we now prioritize repayment of funds to the person who made that extra loan first. So at least you're getting some comfort. And then lastly, on this topic, we could talk about, well, how do we do the exits? But I did talk about the drag along. You want the ability to drag that minority shareholder along for a sale. Okay, moving on to our last topic. It's a good one because it's so related to shareholders agreements. At least the concepts is employee stock options. And I like them. Nothing against them. They're a great method for compensating employees in new businesses. Cash is tight and it's exciting because, long story short, you're just hoping that by the time you exercise the option, the company is worth a lot of money, and now you've got a great deal and a great motivator. So it's excellent. The thing I want to highlight though for you are the key considerations. And I'm going to address this from the context of a business owner. So you want to put some thought, first of all, into the types of shares that you're issuing. You might want to give a little bit of thought to issuing non-voting shares to employees. It doesn't mean they won't participate in future growth, but if they have a different share class, if you have profits in the company you want to pay out to yourself, because that's your intention. Your intention is I pay myself by dividends. That's how owners of companies get paid. You can also draw a salary on the same time. You could be an employee and an owner and get paid in two ways. But if you hold the same share as all the people who hold options and you have $100 to distribute, what you're doing is I'll take $93 and all of you get $1 every time. There's no way around that. So you want to give a bit of thought to that. I'm also not against it all. Everyone just owns the same shares and keep it dead simple. It's okay. You can tie that knot in a shareholders agreement and it will go through all the exercises of control. So I would never be issuing options unless one of the conditions for exercising those options is they're signing on to your shareholders agreement. You don't have to have the shareholders agreement in place, but they're agreeing that they will sign the agreement you then have in place. So that's very important. So other things to consider in stock options, stock option agreements is the vesting period. What's the period of time? Maybe you get 30% in year one, more in year two, more in year three. And the reason for that is to motivate them and keep them tied back. So they always want the options they always want more. People always want more. But sorry, one of the key things, this is almost going to cover option agreements in their entirety of what they have to address and what you have to think about are all the what if scenarios. What if this an employer or contractor, I'll just stick with employees. What if they die? What if they become disabled? What if they're terminated without cause? What if they're terminated with cause because they did something really bad? Your option agreement should really clearly be spelling out what happens in that situation, because you're going to feel really bad if someone leaves the company and all their options keep vesting. You got to spell that out. And then what happens to the options that vested and they don't exercise? How many years does that go on for? Do you just have options out there in perpetuity that are unexercised, and 8 years later you get a notice in the mail saying I'm exercising? You don't want that coming out of the woodwork. So you need an agreement that addresses the what if scenarios. It doesn't have to be overly complicated. And even on the same point, different point, but same sort of thing about the control you want is, well, what happens if we started off with common shares, but now for all sorts of tax reasons, I need new classes of shares and we need to reclassify shares. You want the option agreement to basically say, look, if I want to reorganize this company, I'm going to reorganize the company. I have the right to do that. we'll try and be fair to you. Thank you. Being a little cheeky with that statement, but that's the power you want. You have to give yourself the flexibility in that. So it all ties together. This is founder fundamentals shouldn't be taken as basic, because although these are basic in the sense they're stuff you need at the start, you can see there's a little bit of depth to them, but none of these things individually is insurmountable to wrap your head around at all. It's all basically what we discussed, but then just taking it to the end of the logical conclusions and what ifs. So that's actually all I have for today, and I don't think I've ever talked that long. So thank you. I hope that was informative, and we'll try and I don't know if there were many questions in there, Elena, as they came through. I was sort of had my head down.
Sorry, I'm just going to unmute myself there. Yes, so we'll take questions now. So feel free to put in your questions here. There were a few here, so I'm just going to go back.
I think there's one at the start around 626.
Yes,
what's
I'm
a
just
better? Yeah, what's a better business structure? I mean, I'll answer the easy part of that first. What's better, provincial or federal? I'm more partial to provincial personally, but I don't think it really matters. Even if shipping across country or the US or other countries. As to what structure is better, I mean, I'd love to, we can chat further. I'd like to hear their reasons for why they think partnership. I think corporation might be the simplest and best bet in protection from liability. So the simple answer would be I'd probably lean towards corporation, but it's always worth a discussion to really understand what the motivations might be.
all right. So Juliana has a question here. I think you've answered part of it, but I just want to read because she sent out such a detailed question. What business structure is better to use if I wanted to start an online retail distribution center, buying and reselling items online? Partnership versus corporation. Two of my friends wanted to start a partnership, but I'm hesitant as I think it would be better for the business to be incorporated. What do you think?
Yeah, you're right. Sorry, I should have read that out first. Makes a little more sense.
Okay, perfect. And are you protected while the paperwork for IP is in process?
I'm not. You mean while you're applying or your patent application is pending? I'm sorry, Jason, I don't know the answer offhand. I think you're probably, we'd ask the expert, but I think your position in the queue is going to dictate where the chips fall with that. If someone's ahead of you or behind, I know that's not your direct question. I'm not sure. I won't even pretend to give you an answer on that one, even though I tried.
All right. And Robert has another question. I was under the impression that being a corporation protected your personal assets from lawsuits or financial losses. So I'm guessing he's asking for clarity there.
Yes, in most cases, it will. By most, I really mean virtually all. So it depends if we're asking as a shareholder or a director. So if you're just a passive shareholder, or even if you're an active shareholder, yes, your liability is going to be limited to the amount you've contributed to the company. As a director or an officer, you might have additional obligations. And we call it piercing the corporate veil. So if you really do something scrupulous as a director or officer, just being part of a corporation won't save you. You'll get a lot of deference and a lot of protection, but just the fact that you did it on behalf of or for a corporation is not a perfect shield. So it goes back to acting reasonably, informing yourself, and essentially, well, not breaking the law as a given. But if your question is about shareholders, then yes, it should.
All right. Stephanie, can you expand on choosing federal or provincial incorporation?
Yeah, Stephanie, it is a good question. It does come up a lot. I can just tell you in the field of law that I practice in, which is primarily dealing with privately owned companies, and we could have a lot of shareholders in that. I've never encountered a difference between the legislation that gave me any pause one way or the other. So I almost always these days have been doing provincial anyways. Also because they don't have the direct residency requirements. So for any foreign client, it's just a non-issue and it's a no-brainer. They would go provincial. But big or small company, either it doesn't come up in my world at all. And we deal with a lot of everything from shareholders meetings to financing and capitals and dissolutions. So we've been through a lot, and I can't pinpoint material differences that matter in how it functions. I treat almost every problem between the two sorts of companies the same, federal or provincial.
Great, thank you. Mami has a question. What applies to social enterprises or charities here?
I would say a lot. I mean, forget about the stock option stuff at the end there. But when we're talking, okay, intellectual property, for sure, because even charities and social enterprises are going to have commercial agreements and be operating. In the distinction between employees and contractors, absolutely, that will apply.
All right, great, thank you. While I'm reading the questions in the chat, I just wanted to say, feel free to raise your hands and unmute yourself and ask questions as well, if you're rather comfortable like that. I have a question here from Gideon. I think I had issues with registration because I expected an email and never received one. Oh, sorry, this is not a question, it's a comment. Gideon, I'm going to take you up on that later. Okay. I'll take a question from Earl. What is the closest Canadian business structure equivalent to the American LLC?
I think there are a couple provinces where you can have an LLC structure. I'll be honest, I don't often deal with LLCs. It actually popped up more for me about 5 or 6 years ago, and I haven't dealt with in many years. It's really not that common. It'd be almost 100% entirely tax driven. Yeah, sorry, I can't answer that in much more depth, although it's certainly not a common structure that I see in regularity.
All right, I see Mami has her hand raised. Mami, go ahead, unmute yourself, and please feel free to ask the question.
Pardon the noise in the back. I'm in my office still. So I currently work technically as an organization under a charity at the moment. When we hired, I am an employee technically of the charity, but then when we're hiring, we give them the option of being a contractor or to be employed by the charity as well. I get a little nervous because I'm not sure what is the best practice when you're working with people who have never been a charity or have never been their own contractor before. So we basically worked under yearly contracts, meaning like at the end of the year, we'll give a review and then we'll rehire you again. I'm wondering if it's better to put them as an employee or if I'm wondering what the best option is for those kind of situations.
Yeah, it's a great question and something that comes up a lot. The truth is it's going to depend on a little bit more of an in-depth discussion to really understand the role, the obligations of this person, the degree they're only working for your company, the amount of oversight the company has. So it gets a little bit into the nitty-gritty.
Right.
I'd be a little uncomfortable with the general premise of giving people the choice without understanding more. Mm-hmm. Because it just seems like a situation where you might have people doing the exact same roles, but the classification is different across the organization,
right?
Which might be a bit of a red flag.
Okay, I guess that's just like a further conversation then.
I think so, because it's, yeah, we'd have to go through a bunch of factors just to understand the dynamics a little bit more closely.
Okay, I do have another question. I think I have two, but my other question was, Tim Hortons structure, they have the business of like selling food, but then they also have the charity side where they have the camps that they run. What is that? Is that what a social a social enterprise is, or is those two separate entities?
My guess is, well, they'd almost certainly be separate entities, like a charitable arm. And by arm, I mean completely distinct, because to get a charity is a charity law is it's almost like a own unique subset, and it's quite a rigorous registration process to become a registered charity. So they certainly probably are not operating under one corporation that's doing both. It's probably just all under the umbrella of the Tim Hortons brand.
Okay. And then my last question is, if you're in the middle of trademarking, is the only way to make sure that your product isn't, or your logo, whatever you're trademarking, isn't taken is at the end of trademarking, or is the process of trademarking as like valuable as actually being trademarked?
Yeah, that's something I'd have to defer to our related colleagues that we deal with at Smart and Bigger that have joined us for these presentations before. But trademarking is certainly the best you can do, but there is a lot of protection also for brand recognition and your names out there. And half the battle most of the battle without being trademarked is how prevalent you are in the community. It counts for a lot. So you do have some protections even without a trademark, but trademark basically solidifies it.
Okay, thank you so much.
Oh, you're welcome. Thanks for your questions.
All right, thank you for that. Mary has a question for virtual health business. Would it be better to incorporate as a corporation? That's the first part of the question.
I mean, I think so. It's sort of similar to the previous question as what's better, the partnership or a corporate entity. I would say 9 times out of 10, I think the corporate structure is going to suit you better, but it is a personal question and how you want to operate and all that. But I'd say your big competitor here, unless I knew more, was maybe just remaining as a sole proprietor and make sure you carry insurance if we're dealing with health. And
the second part of the question is, when should you set up a shareholder agreement when looking into investment opportunities?
I'm not sure what's meant by the last part, when looking into investment opportunities, unless you're thinking about making an investment in a company yourself. Okay, I'll try and approach this from 2 different angles. One is just the initial premise of when should you set up a shareholders agreement. I think unless you're at the outset might be a little premature, like on the date of incorporation, unless you're just ready to go. Everyone's putting in money, you know what's happening. But if it's really, hey, let's incorporate, get the ball rolling. So my answer to that would be, first of all, before things get too contentious, maybe once you've figured out and delineated a little bit more clearly what the rules are, and before you've invested serious capital, you just want to prevent a scenario where someone's really put in a lot and is going to feel very jaded if things don't shake out in that shareholders agreement because everyone else isn't on board or quite as appreciative of what's been happening. So before you think that sort of tension might be built in, but it's a tough thing. I'm not going to downplay it. And then if the other half is when looking into investment opportunities, if that's like investing in another company, you might want to better I'm going to assume you're investing as a minority shareholder, something like that. Oh, hi, Mary.
Oh, hi, sorry. What I meant was when looking for investors, actually. So, when looking for investors to like support with green their company. So how much should you sort of like pay them out with regards to dividends? So it was more so around that arena.
Oh, okay. So potential investors looking to invest in your company.
Yeah.
Yeah, I would absolutely have one then at the outset, depending on the investor and if they're buying shares right away or if they're getting something like safe notes. I'm not sure, but I think it's a good idea. I'd be a little surprised if the investor themselves didn't want a shareholders agreement so that they have certain power over some key decisions. It all depends on the size of their investment. If I was a minority shareholder buying a decent stake of 10% plus in a company, I would sort of want to guarantee that I have a seat at the table. Because like I said earlier in the presentation, the minority shareholders don't actually have a lot of power to block a lot. They can just be a real pain if you're going to sell the company. But I would want some control over how you're going to run it from their perspective. So there might be more to it than that. If they don't want an agreement, Mary, maybe you don't rock the boat too much, unless you're concerned about how to drag them along in an eventual sale or things of that nature.
Thank you.
You're welcome.
Great, thank you, Mary, for that question. Charles has a question. If you are a sole proprietor and you have the insurance, can you trust your insurance to protect you from liability?
That's probably a very important question. I mean, I'm not sure. I would. If I'm not sure, I mean, I would assume so. As long as your policy, depending on your policy, but for commercial general liability insurance, I would expect you to have pretty broad coverage, although everyone says don't trust insurance companies, they'll look for ways not to pay, but by and large, I would believe so.
All right, great, thank you. Carlos is asking, is it easy to change from sole proprietorship to corporate, or should open a new business under corporate and close the sole proprietorship?
Yeah, that Carlos, you hit the nail on the head, because that would be the natural transition, right? You start off sole proprietor and then you become a corporate entity. It's all going to be fact specific on the type of business being conducted. So what I mean by that is, picture yourself, you're a sole proprietor and you have 10 different agreements out there, each 1 year in length or various terms. So it depends on what you're doing, because if you have 10 contracts with clients and then you want to incorporate a company, well, no one's stopping you from incorporating a company. You can just start doing business under that new corporate entity easily. But what you really want to do is you want to shift all those contracts and your operations into the corporation. So what I'm trying to say is, it depends on the assets of your sole proprietorship and what you're trying to funnel over to the new company. So if you're tied into a thing like a lease, for example, what you're really saying is you're going to be knocking on your landlord's door and trying to get your company on the lease or something like that. So it depends on the underlying contracts you have. But the sole proprietors that I've moved over, it can be pretty easy. We incorporated a new company. We let go of the business name. The 1, 2, 3, 4, 5, 6, 7, 8 Inc. becomes New Business Inc. And you open up a new bank account, and we talk with your tax advisor about transferring assets. And that's the only complication, but that might not even rear its head. So it depends a little more what you have going on in the business, Carlos, but it shouldn't be convoluted.
Great, thank you. Charles, please go ahead with your question.
Do you trust owner to incorporate?
Yeah, I've seen them around. I'll be honest, I've never done it through them. I should almost bite the bullet and see what it is, because I've seen them crop up more and more. I'm on their site right now, and it looks like they give you a minute book and things like that, which leads me to believe that they're doing the organizing part of your company, which is good. So I'm just going to go ahead and assume they're going to issue you shares, name the people you want directors and officers as that, and they cover all that. If so, then yes, I would hope so, because like I said, it's not that complicated to do it right. And I'm presuming they got the formula. Where they might fall down is some of the topics we've discussed I want different share classes for minority shareholders, stuff like that. But if it's just, hey, I want a company, I want one class of shares, that's it, I'm good, then I would hope they've at least nailed that down. I'd be surprised if they didn't.
Can I ask you another question? So people go on about the tax benefits of being incorporated, and I'm just trying to wrap my pea brain around this. So you're taxed at like 12% instead of your income tax bracket, which is much lower. You can invest and grow that at that rate within the company, but that's in an unregistered account. So that account, your capital gains and dividends will be taxed as opposed to your RRSP, because you're not paying yourself that money. You've restricted your RRSP contribution room, which would have been a tax advantage. And then eventually, when you do withdraw that income, you're taxed at your income bracket on top of that 12%. But you're saying that in the end, it still works out as a tax advantage to invest within the corporation and then pull it out one day, as opposed to paying yourself and investing privately.
No. In some respect, yes, but I'll explain. If you're a business and you're trying to reinvest funds into the business to grow it, is one half of the equation. Then the other half of the equation, which I think you're describing, what you are describing, is the personal tax treatment for your own life and wealth planning. So if you're going to grow, and I'm not a tax advisor, so take it with a grain of salt, please. But if you're growing the business and you're reinvesting funds, you have two options. So you funnel all the money out to yourself personally, you pay your tax bracket, and then you use your after-tax dollars to reinvest in the company. Or you keep it in the company, which is hopefully taxed at a lower tax rate than your own personal tax rate, and you're using the funds that are taxed at 15 to 25% or whatnot back into the company. So in the latter scenario out there, the money never even hit you. You just stayed in the company, lower tax bracket, goes right back out. And then the other half of, sorry, I'll stop right there. Does that make sense, that part?
Yes, yeah, thank you, that's very helpful.
Yeah, no, it's the key question. And I honestly, if I had to go start my own business tomorrow, I would sit down with a tax advisor and just say, this is the scenario, run it by me, let me see the numbers. And the other scenario for your wealth creating is the fascinating one, because that's the big question. If you're just making a lot of money in the corporation, do you start using the corporation as your investment savings tool, or do you funnel it out to your RSP? And then there's countless things online that have crunched the numbers and run it out and what's better in the long run. I know a lot of people with successful businesses will incorporate holding companies above their operating company, and they will funnel the money tax-free. You know, you're paying tax once at the corporate level, but they'll transfer it tax-free to a holding company. And they will use that holding company as nothing more than a vehicle to now invest in unregistered accounts. And they will never have it hit themselves at the individual level. Maybe they do so and they max out their RSPs. But that gets into the good problems to have territory. Is I've got enough excess capital that this is a real decision.
Yeah, that sounds pretty good. So yeah. The holding company, how do you access, at what point do you access the holding company?
Yeah, when you have enough money to justify having a holding company. I don't mean that to be a short response, but there's a couple of reasons you might have it. It's all going to involve tax planning when we're getting to that level, because you're going to say, okay, a lot of wealth is being created here. I don't want to hold the shares in my name anymore. I want to freeze the value of my shares today, and I want the future wealth to flow up to a holding company. Because keep in mind, when you incorporated presumably with you as the sole shareholder. And if you're on the line here thinking, well, why don't I just go holdco as the shareholder right away? It's not a bad idea. But what you're doing then, if your holdco is the shareholder of your operating company right from the get-go, is you've almost rolled the dice and bet on yourself, because you're sucking up some additional expenses and saying, I'm going to make it. And this is a great tax efficient way to maybe hold it. So that you'd be doing a tax maneuver at that stage of the equation to shift and issue new shares to this new company you've created. And we start talking about the lifetime capital gains exemption that I was talking about. So let's say your business is worth $1 million, but you're not selling it. What you can do, and this is well into tax advisory territory and beyond the scope of the founding stage, but you would take back preference shares worth $1 million. So you just traded in your commons and you took back prefs, and don't take this as the answer, but you take back the prefs. And now you have $1 million worth of pref shares that are never going to grow in value from this day forward. You'll lock yourself in at $1 million. Your holding company took back shares, common shares issued for nothing, because the $1 million of value is locked up in you. And now your holding company is created and is going to get all the future wealth creation of the company. Is something you could do. The more common example or option is you don't even use a holding company. You do a family trust. And way back in the presentation, I mentioned that you could split this $900,000 capital gains exemption 6 different ways, everyone in your family trust. So your company goes from $1 million to $5 million. And this is why the rich get richer, maybe. The family trust will let not just you, who already have your first $1 million locked up, it'll allow your son, your partner, your grandmother, if you named them, to get $1 million tax-free.
They each have $1 million? Every
yeah,
person?
you can do it that way. It's not as complicated as it sounds. You sort of need to see it on pen and paper, and all I really did was say, you took back preference shares and we issued common shares to your family trust. That's all we did. But yeah, there's tax. The tax lawyers are the smartest lawyers because they figure out all the loopholes of how do we do all these tax restructurings. But that's sort of the beauty of corporations from a tax perspective. Sometimes there's a lot of tax things you can do to do what I sort of described there, albeit confusing the issue somewhat, but it gets interesting.
Thank you.
Oh, you're welcome.
Great. Thank you, Charles, for the question. Winnie is building on to Charles' question, and she wants to know that when they change from sole to corporation, would the landlord have a right to raise rent or terminate the lease?
Well, nothing would change. Just because you incorporated a company doesn't mean you changed anything with your landlord. You don't unilaterally have the power to do anything with your lease. So all the landlord's going to care about is your name is on that lease and you promise to pay the rent. And there's no way a landlord is going to change your lease from your personal name to a newly incorporated company with no assets. So maybe that was a bad example. The more realistic example is with your clients and customers who you're now going to try and say, it's not me you're dealing with the corporation. So the difficulty in transferring your ongoing business at a moment in time to your corporate entity will depend on, are you locked into contracts that have a term to them that you can't get out of? Yeah.
All right, great. Yu Chen is asking whether how would they know if an industry or area is regulated? They're particularly wanting to find out about a pet food related business.
Yeah, that would take some research. It's a good question, and it could be a bit of a blind spot. So there's no easy answer to how, and I don't know the answer off the top about that industry, but it is a tough thing to navigate just to make sure you're not missing anything.
Great, thank you. Planning on starting a restaurant. So far, we know only the name. When is the best time to register the business?
So I guess the difference, or what is the question that like register and just become a sole proprietor or incorporate? If you want to register, sorry,
go ahead, Alex.
Oh, I was going to say, if you want to register and become a sole proprietor, then anytime, no time's a bad time. You might as well. Or if you want to incorporate and things might get complicated because I'm assuming if you're going to start a restaurant, you might have to lease some space. Maybe you want to incorporate sooner than later, especially in a restaurant business with food and people ingesting things and your operating space and slip and fall accidents and all that kind of stuff. That is a type of business where incorporating sooner might be of value than sitting on it and just sort of seeing how the liability shakes out. Maybe I'm just nervous because I'd be scared about, well, even slip and falls alone on your premises. It becomes a bit of a nightmare.
Yeah, great. Gideon is asking, are there any income tax exemptions for social enterprises in Canada? What other exemptions or reliefs are there?
I'm sorry, that is outside of my scope of knowledge. I wish I could answer that, but that's pretty specific and heavily tax weighted. I'm sorry.
All right. I have another question. It was sent in by Elisha. Let me just pull it out here. The question is to do with property ownership within an incorporated entity. If your business is managing property, is your incorporated business allowed to own property and other assets? In this case, would closing costs be considered expenses?
So the first part of that question about restriction on owning properties, I can't see why there would be a restriction. I don't think I'd have to look into that further, but no, I don't think there's no restriction I know of, put it that way. And what was the second part of that question, Alina?
Would closing costs be considered expenses?
Yeah, this is a very tax heavy group. I mean, I would rely on the tax advisor for that, but I would imagine they would be, but that would be your accountant or your tax advisor to answer that one.
Right, great, thank you. And just adding on to that, we do in the series have grants and government initiatives session also, in which especially focusing on social enterprises, these topics will be covered. Okay, so Robert has another question. Is it safe to say that any business related to food should be incorporated?
It's all a personal preference for risk, really. I think it'd be the cautious approach to do it that way. Like I said, directors have personal liability, but a corporation does provide a heck of a shield from liability, especially if you're acting in a reasonably prudent manner and really diligently trying to be safe about it. So I think I'd feel most comfortable from my perspective being incorporated in food and beverage.
Yeah, great, thank you. Are there any more questions? Does this extend to drivers and people that deliver food for you? It's just a follow-up question for food business to be incorporated.
Oh, okay. No, I'm not as concerned about someone working on my behalf. It's really just the food and ingesting and dealing with people in that manner. And people can be litigious and who knows who you run into. But yeah, anyways, it's really just because it's being adjusted that gave me pause.
All right, great. If you have any more questions, please feel free to just. All right, Robert has a question. Would drivers be better to be on contract?
There's no, it's going to come back to the test, Robert, essentially. It depends how many things they're checking. If they exclusively drive for you, you're their only employer, you tell them exactly what to do, it's your car. I'm not saying those are all determinative factors, but put those together and I'd say, I don't know if you have a choice from a purely legal perspective. It sounds like an employee. So it'll go back to the test. And unfortunately, it's a semi-subjective, objective test. A bit of gray, but yeah, I would say it's common to have them on contract. But like I said, protect yourself and say, if you're on contract, get them to say in writing they deliver for other companies, have them use their car, things like that. Yeah.
All right, great, thank you. Charles has a question. If you have a corporation and a sole proprietorship, can a client from the sole proprietorship business sue you for your shares in your cooperation?
Sue you for your shares. Yeah, you know, best way to think of shares is they're an asset of yours, just like anything else. Not to compare them to a car or cash, but that's what they are. So if you got sued at a personal level, you guys are finding all the holes in my knowledge. I'm not a litigator, but yeah, they're just another asset that a creditor could go over. So it depends. It's not like they could sue you specifically and say, give me your shares as a client. That's not how it would work. But if you did something and you were in breach and there was damages and you had no cash, no other assets, and all you had was the shares in your company, that would be fair game. I would imagine. I don't see about any reason that would stop you. It would stop them.
All right, great. Just seeing if anybody has some last few questions. There are a few questions regarding the timings and whether this workshop is being recorded. This workshop is being recorded and will be made available on our Yspace YouTube page. I will also be sending you an email with the link to our to this particular session for those who could not join us today. The series happen every Tuesday, 6 p.m. to 8 p.m. I've already sent Alex's presentation to all the people who registered. In case you haven't received it, I would request you to please check your spam folder, or you can always reach out to us at our York Yspace email address. I'm just going to put that in our chat as well, and I'll make sure to get you Alex's presentation. Alex, I think there are no more questions. So great. Thank you so much for imparting your knowledge and expertise on the legalities of setting up a business. On behalf of Markham Small Business Center and Yspace, thank you so much for sharing your insights and your resources. This was a very, very informative session. So thank you so much for being with us today. And to all of the attendees, thank you so much for joining today's Founder Fundamentals session. Before I let you go, I just want to remind you of all the great programs Yspace has to offer, particularly the ones that are upcoming. Just going to quickly share my screen here. So as I discussed at the beginning of the session, the Venture Catalyst program the applications for it is open till October 2nd. So if you're an early stage tech company, you can certainly apply for this and get mentorship. And you can also, if you haven't done so already, you can register for the remaining Founder Fundamentals workshops next week. Next Tuesday on October 4th, we have Finance 101. And basically, it's going to cover various financial modeling models to protect businesses, and also the various aspects you need to consider when looking for investment and funding. Having said that, thank you so much for joining us today. I'm just going to stop sharing my screen here, and I'm going to send a survey link into our chat. If you guys can please send, if you guys can fill up the survey, that'll be great. Thank you so much, everyone. That's all for today. Have a wonderful day. Thank you so much for joining us.
Thank you so much. I really appreciate you having me here, and thanks for all the questions, everybody. Really appreciate it.